Hello and welcome back to my channel Court.foreign. Today I am once again before you guys to discuss one of the important legal issue. Today I am going to discuss a judgment which is recently delivered, that is on 23rd of February 2024 by NCLT Bombay. And this is this particular judgment is delivered in my own matter, and that's how I am about to discuss the context of the judgment. You see, what if the corporate debtor, which has no registered office in Mumbai or in India, and which is in fact a foreign based company. Here in my case it was a Malaysian based company, and they didn't had any registered office in India, and for that matter in Bombay. But they enter into some service contract with an Indian entity, and in regard to that service contract, they receive some services. Now, these services which is been provided by the Indian based company, which is in my case is an operational creditor, a shipping giant, and has an office, a registered office in Mumbai, Andheri. Now, this operational creditor provided service to this foreign-based company which has no registered office in Mumbai, though they were dealing through their subsidiary company which is registered under the Indian Companies Act and have the registered office in Mumbai. Now, services were provided. These services were pertaining to logistics services which were provided under a work order, and subsequently the invoices came to be issued, and there was no dispute as regard to quality and quantity of the service provided. Now, after services being availed by this foreign-based Malaysian company through their subsidiary company in Mumbai, they failed and neglected to pay the invoice amount for the work done or the services rendered. So this led to exchange of various emails and communication between the party, that is the operational creditor and the corporate debtor, which is in my case is actually the holding company which has no registered office in Mumbai, is a Malaysian based company. I am not disclosing the name of the either of the party for no other reason but to just keep the things under carpet. You may read the judgment if you get those judgment. That's a different context, but I am not going to name the companies. I will refer to them as a operational creditor and the corporate debtor. Needless, now eventually this communication led no concrete and positive result. Therefore, the operational creditor issued IBC notice to this foreign-based company which has registered office in Malaysia. And this notice, which was issued by the operational creditor, was in fact received by the corporate debtor, but they did not prefer to counter or reply or comply with this notice. Obviously, the next step was to file an IBC petition before NCLT Bombay. And on instructions, the NCLT proceedings came to be filed under IBC Act before the Bombay bench. However, the Registrar Bombay of the NCLT bench had taken some objection. The objection was very crucial objection, not a technical or administrative objection, but it was a legal objection. They came with an objection that, look boss, this corporate debtor has no registered office in Mumbai. What they have is an administrative office or corporate office. They are functioning through their subsidiary company in Mumbai, which has an office in Andheri. And as per the RBI mandate, if a foreign-based company has to function in India, they need to have an offices and need to have an FCRN number. But under the MCA data, they will not have the CIN number, which is mandatory for the registered companies in India under the Indian Companies Act. Now, sans CIN number, this petition cannot be allowed to be registered because that is not the mandate under the Act. We will not allow this petition to be registered and listed for the hearing on the basis of the FCRN number. Catch 20. Now we were helpless. What to do? Then I asked my client, which is operational creditor, to provide me everything, all communication, all invoices, all work order. And on perusal, I found that in fact, the invoices and the work order were issued for this holding company through this subsidiary company in Mumbai. And on the right hand side of all those invoices, the name of the subsidiary company were mentioned. And the invoices and the work order were signed, digitally signed by Indian executive who was sitting in the subsidiary office of this holding company. Not only that, there were communication exchange on email admitting the liability on behalf of this holding company by this subsidiary company and the executive who has signed his invoices and the work order. I brainstormed my law and on the facts, and then I decided, sought an instruction from the operational creditor, can we issue the notice again to the subsidiary company which has a registered office in Mumbai. Obviously, client instructed, and then accordingly the demand notice came to be issued, which is Form 3 and Form 4. I am not going to elaborate detail about that. We all know that who are practicing. And consequently, the demand notice were issued to this Indian-based subsidiary company of the holding company which has the Malaysia address or registered office in Malaysia. And petition came to be filed after even this demand notice, despite being received and acknowledged by this Indian-based subsidiary company of the holding company, they did not even bother to reply. I went ahead and filed the petition through my client's instruction. And that is how the petition was, of course, after removing all those technical objections, was listed and the notice came to be issued. After the notice was issued to this Indian-based subsidiary company, they came with a counter and raised a preliminary objection of the locus standi of the operational creditor to file IBC proceeding against Indian-based subsidiary company for the debt of the holding company. Because there is no privity of contract, that is what their contention, and I have no locus. That is what my client has no locus. A reply was countered by filing a rejoinder, and then we eventually narrated entire incident, included the definition clause of the work order in the invoices, and also annexed those communication, though these communication were already annexed with the original petition, but for the sake of brevity we again thought it fit to again attach with the rejoinder. Now we refer to the definition clause in the work order as well as the invoice, and specifically emphasized on the definition of the group company or group entity or group buyer, which was very clearly mentioned under the definition of the work order and the invoices, which were digitally signed by the executive for the holding company, who was sitting in the office of the subsidiary company and functioning, discharging everything from that office of the subsidiary company. And this definition of the group entity or group buyer was very clear, which included any affiliate, associate, assignee, or anyone claiming through the holding company, any enterprise claiming through the holding company. And that is how we prepared the rejoinder, and it was submitted to the NCLT Bombay bench, and the copy was also provided to the corporate debtor. Matter was listed for final hearing, where the written arguments came to be filed from both the parties. The respondent, that is corporate debtor's main claim or main emphasis is again on the locus standi, and there was no privity of contract. And since there is no privity of the contract, the IBC provisions against the respondent, that is corporate debtor, is not attracted. And there is no relationship of the debt and the debtor. That is what the paramount requirement under the Act to file IBC proceedings. After perusing all the documents, petition, annexures, reply, rejoinder, and the written arguments for both the parties, that is operational creditor as well as the corporate debtor, the NCLT bench Bombay came with a beautiful judgment. I'm not saying because of the issue that it happened in my own case, but this is very important. Look, I'm providing this detail, rather trying to make a video on this particular subject with an intention just to make others enlighten the main issue, which I'll deal with later on. The judgment is very beautifully delivered, beautifully worded. Now the judges have, the presiding officers have dwelled into the relationship of the debt and the debtor, and they have given a reason that since this subsidiary company of the holding company, which has a registered office in Mumbai, have in fact duly acknowledged the debt through various email communication, and even their invoices and the work order were digitally signed by an executive sitting in Mumbai office of the corporate debtor, and he in several communication have acknowledged the debt on behalf of the holding company, and even going ahead very clearly that they are willing to clear those dues. So there is a clear-cut communication, and of course the reliance upon the definition of the group buyer was helpful to establish a relationship between the operational creditor and the corporate debtor as a debt due and the debtor, which is the paramount mandate to file the IBC proceedings against the corporate debtor, which is established on document admittedly, and this has been observed by the learned judges or learned presiding officers while delivering the judgment. So on the basis of this admission, the privity of contract came to be established. One. Second, the relationship between the operational creditor and the corporate debtor came to be established as a debt due and the debtor. And third and foremost important is this subsidiary company, which is the subsidiary company of the holding company which has a registered office in Malaysia. However, this subsidiary company has a registered office in Mumbai. The issue of having a registered office of the holding company in Bombay were not given that much relevance, keeping in the mind that subsidiary company has the registered office in Mumbai, and that is how all the compliance and mandate of the NCLT Act and rules are complied with. And here we have, in fact, in petition as well as in all our counters, have specifically mentioned very clearly in written arguments also, and while canvassing the oral argument also, why this petition came to be filed on behalf of the subsidiary company. We have clearly and very candidly given the exact facts which led to filing of this petition, for the reason that initially when we filed the petition on behalf of the holding company which has no registered office in Mumbai, that is how no CIN number could be provided, though they have the communication or administrative or corporate address in Mumbai and have an FCRN number, but NCLT bench Mumbai did not allow my petition to be registered. And not only that, this fact was brought to the knowledge of the registry and also on the oral mentioning to the bench that the petition filed against the holding company is not been allowed to register because the FCRN number is there and there is no CIN number which could be provided for the lack of registered office in Mumbai for the holding company. This was disclosed very clearly in petition, in the counter and in written argument. So there was nothing which was hidden from the court. Court took everything in consideration. So this all objections that there is no registered office of the holding company was considered but not been given much of relevance for the reason which I have already discussed. Then the privity of contract is clearly established. Then the relationships of the corporate debtor and the operational creditor as a debtor and the debt due is clearly established. So the IBC provisions are clearly in place, and that is how the petition can be admitted. And that's how the petition was allowed to be admitted, and the RP is been appointed. So I thought of updating this issue through this video, and that is how this video has been made today on this subject. So if in future, earlier I have already told why I'm making this video, is if in future, if any of you or your client comes with an issue that some foreign based multinational company which has no place of registered office in Mumbai or in India, though they have some communication or some correspondence or some administrative or corporate address in Mumbai or in India, and they are operating through their subsidiaries in India, will the IBC proceedings can be filed even if there is no registered office of the holding company in India or Mumbai. The judgment clearly establishes the case of citation where you can rely upon in a similar and identical facts in future and rely upon this judgment, which can be helpful to the operational creditor. The only condition should be satisfied is that in all those matters, the relationship of the operational creditor and the corporate debtor as a debtor and the debt due and the privity of contract should be emphatically and clearly established. So thank you very much for watching my video. I shall come back again on some other legal topic, and I am happy that you are watching my video, and I shall request you guys to keep watching and keep supporting and keep blessing us in my all these videos. Thank you very much and have a nice day.